Good afternoon, ladies and gentlemen. It's a pleasure for me to be here, and hopefully I'm the last but not the least. I'm talking about a new German standard which was set up in 2011 after a while, so it was not a rabbit out of the hat. It took a while, it took many months, and I was a member of the working committee who set up this standard. There were different people from different fields of industry and lawyers and universities, and we were discussing how to set up the standard. And during this procedure, we also tried to set up an international standard, and the opinion was very different in different countries about the question whether you really need a standard. So actually, some countries, they have the opinion that this cannot be standard, there cannot be a real standard for patent valuation. But we, in our expert group, we agreed that there is an option, but we wanted to set up a framework for valuation. Because I remember, even you can see, if you already got into the internet and saw the Patent Valuator website, you can input a number of a US patent and you will get directly a value. So this is based on the US GDP, how it is calculated, the share of this patent of the total patent in the US, and based on this there is a value. And I was thinking you cannot evaluate or you cannot valuate a patent without having a technical background, without reading the claims. So this is the background, and that's on this perspective the German standard is based. Of course, a standard as such has no value as long as it is not cited by other rulings. But on the other hand, if you are before a court and you have to discuss value and the result of valuation, it's always a benefit for you to cite a standard which explains how to do it, and if you stick to the standard. So sometimes really even the clients who ask me for a valuation, the scenario was similar like that, but not from my side, from the side of the client. Often when a patent is to be evaluated, for example, a mother company wants to sell the patent to a daughter company, they sometimes really tell me, the value does not have to be more than this or something like that. So it's always a thing, but we cannot do it like that. So maybe you can play with the risk factors or something like that, or with the income, the expected income. But normally it's not possible to set up a value and to try to trim your valuation report to the value which is required. So interesting is this court citation which I got. This is from the court in North Carolina. And you see what the judge said. This case demonstrates the extreme difficulty in valuing a company which has no assets other than IP that is untested in the marketplace. It demonstrates the necessity of having well-documented provisions in place for valuation upon departure of one or more individuals that participated in development of the technology. So you see, if there is no person who can tell you something about the content and about the patent, it's very difficult to obtain a method how to evaluate such patents. And we have a certain framework in the standard where, for example, we use the royalty relief model, which is often very helpful if you don't have much figures about this. You need a certain turnover figure, of course, but with the relief from royalty, this is a thing where just say, what does the patent owner save in royalty payment if he has the patent and the competitor needs to pay the royalty for the patent. So this is one approach which would be allowable according to the German standard. So we heard about this major problem. If you have a patent portfolio, this is the distribution of value, and you see there are only very little patents who have really a high value. So the rule of something about 1090, you can say 10% of the patents have 90% of the value of the whole portfolio. And this is the main problem, how to find out these patents. And but of course, it depends on the figures you have available. So I think reason for standardization, it's clear. We have already heard how many options there are, where you need a value of a patent. It may be a transaction, or it's maybe internal controlling of the company for evaluation of return on R&D. There may be company valuations, that's very often the case. Monetizing IP is more and more increasing. And the portfolio management. So far, yes. And also, the basic valuation concepts were already mentioned by Anders. I have structured it a bit different, but it's actually the same. You can have the income approach,
The value is determined based on the net present value. That means that future cash flows are discounted to the present time based on future patent-specific earnings. With the patent-specific, we mean that you have to find out which of the income is really based on a patent, which is one of the difficult things. And then there's the market approach, where you just look whether there are is there a similar transaction, a similar patent where you can compare the prices, but this is very seldom used, this approach, but because you don't have an active market for patents. Maybe this will be better in the future where we have more and more transactions, but actually the income approach is favored. Then we have the cost approach, which determines the value based on production or reproduction costs. So what would it cost to reproduce the invention, actually? But you can discuss, normally a patent is a similar thing, is a unique thing, so you can't reproduce a patent, actually. We could do it based on the invention, based on the efforts put into the development. And then that was the major point why we also started setting up a standard was these statistical approaches, because a lot of companies came up in Germany who also offered valuation only based on, you needed just to give them the figure, the number of the patent, and they only based on the patent without any technical deep developments or investigations, they gave you within 24 hours, they gave you the value of the patent. So this is a problem. It can be, if you have a big portfolio, this can be a solution, but if it's only 1 or 2 patents, this cannot work. Because if you don't read the claims, if you don't look what is the technology, to me, that's not possible to derive a value only based on a statistical method. So this was the working committee of the German Institute of Standardization called DIN, and this is in Berlin. And so the initiative was made by a group of experts who said it may be advantageous to have a standard in Germany. And so you see the composition with 7 industrial representatives, including people from Siemens, for example, and a big pharmaceutical company. 6 legal representatives were mainly patent attorneys, 3 consultants from business consultancy field, and 3 scientific representatives. So this was the working group. And it took a while, and interesting discussions came up during the setting up of this standard, because especially the views between the business consultants and the patent attorneys were very, very different regarding what is the value of a patent. Because for a business consultant, the value of a patent is the value of the invention, while we say the invention is not the patent. So this is very difficult, but because the business consultant would say, if the patent is withdrawn, you still have a value. But to me, if the patent is withdrawn, normally the patent has no value. Only if you look at infringement for the past, that's okay, but not for the future. So what are the major requirements of this standard? As I said, it's just a framework for valuation. We don't give a real recipe how to evaluate so that you can just use it step by step. We have a framework. And actually, it is applicable for patents, single patents or patent applications, utility models, or even more, a set of patents. The requirements especially are comprehensible to the addressee. So you see, we don't only give a standard for how to evaluate, also we give a standard of how to present, how to report the valuation. And this is very important. It should be comprehensible to the addressee. So even if the addressee is a layman who has no experience in evaluating patent, he should still be capable of reproducing how we came to this value. The second requirement is reproducible and verifiable to an expert. So the expert should be in a position really to calculate this again. It's not possible just to write down the value is this and this. So we need really to structure this report in a way that it is reproducible. And you need to address in your valuation report the motive, purpose, and addressee, which, for example, means the motive may be someone wants to have a bank loan, so then the purpose would be a securitization. How can this bank loan be secured? And the addressee then would be the bank. So this is an example, and this should be mentioned in the report. Because always every value you obtain depends on the exploitation scenario. So what is the scenario? How is the benefit, the economical benefit generated? And it's absolutely different if you value a patent which is used by a company than if you value a patent which a bank wants to buy, because the bank is in a totally different situation.
In the company, the patent is in use, so you can directly calculate, are there license incomes, is there turnover generated by the products? But if the bank gets the patent, you have to start from the scrap. You have to look what is the market, what is the potential market share, which you can get with the patent and where you can receive licenses. This is what's now next point. An underlying exploitation scenario should be indicated. So at the beginning of the valuation, you define the exploitation scenario. There may be several scenarios. It may be some external value may be generated by licensing out the patent. In addition, you may use the patent in your own company, which is an internal value. And this should be two separate things which are added at the end of the report. Of course, the valuation is time dependent. So if you establish a valuation report, in the end you get a value, but this value is closely fixed to the time when you made this valuation. So maybe 1 month later the value is totally different. Maybe the patent was withdrawn then, or something else, or there was a nullity suit. So this is very important. You cannot derive a value which is the same forever. And valuation approach and method must be selected, and reasons for the selection must be documented. This is the point. You can use even the market approach or the cost approach, but then in your valuation report you have to indicate why you didn't use the income approach. So we have a kind of hierarchy of these approaches. So what is based on this priority of approaches or hierarchy, we have set or mentioned in the standard that the monetary value is preferably determined by future cash flows, positive and negative. Negative cash flows are, for example, saved production costs or something like that, resulting from the use of the patent according to the determined exploitation scenario. So this is one requirement. And of course, what now comes in, as we heard already, we have to consider the risk. And this is done by factors of influence. So we defined in the standard, we defined even a list of these factors. We have the legal factors, the technical factors, and the economical factors. And this is a kind of, you can see this is a kind of checklist, because if you do the valuation, you have to tell or to explicitly mention in your valuation report why you didn't consider, for example, scope of protection or freedom to operate. There may be reasons why you didn't do it, but it should be mentioned why not. So these are, for example, minimum factors of influence which should be mentioned in the report and which should be considered. And the risk may be considered by two different things. You may modify the future cash flows by a certain factor which is based on the risk, or you may change the discount rate. You may adapt the discount rate. I come later what this means. So here you see we have this prioritization of evaluation approaches. So if you stick to the German, if you want to do a valuation based on the German standard, you need to look at this prioritization, and if you, for example, if you want to use the market approach, you should introduce some arguments why you didn't use the cash flow oriented approach. And with the highest priority, the approach would be the incremental cash flow. This means you really have to look at the patent and the products which are covered by the patent, and based on this, you define the economical benefit. For example, if you really can allocate in your company, the use of the patent provides us this economical benefit, then you can use the incremental cash flow. But if you don't have these figures, if it's not possible, there are so many patents involved, the better way is to use the relief from royalty. The relief from royalty means that you look at your turnover. I show you an example later, and based on your turnover, you just say, as I'm the patent owner, I do not have to pay any royalty fees, so I can use this spare amount of money to calculate the value. To me, this is a very reasonable approach. And then we have the market approach, and the least one which should be selected is the cost approach. Because in the cost approach, you do not consider any future benefits, and these are really important when you evaluate a patent. So if you use a suboptimal selection, it should be justified based on the available information. And you see, I just added here, if someone is interested, you can have the English version based on this web URL. In the website you can download it, but it costs about, I think, 50 or 60 euros. So how is a typical valuation done? It's just, we go briefly through this. First of all, of course, you determine the IP rights to be evaluated and the ownership checking. Then you determine use and users in one or more exploitation scenarios. So you have to think, if you're the evaluator, if you do the valuation, you think, where is the money generated? Where does the economical benefit come from? Then you can determine factors of influence. You can check this list in the standard and you look which one is relevant, where do I have the data, and if I do not have any data, I would just tell this is not available. That's the reason why I don't use it, or it's not possible to calculate it. Then it's very important is the expected economical useful life. There is even from a German tax institute, there is even a proposal where they say it's for 8 years would be a good value for this, if you don't have any real figures. It depends on the product cycle, of course. And then you can determine, based on this economical use of life, determine resulting positive and negative patent-specific cash flows. If it's the royalty relief method, this is just a saved license fees per year. And then you make a risk adaptation based on the risk defines, and in the end you calculate the net present value by summing the discounted cash flows. This may be not very known to you, but I'll show you an example. It's typical in the case of valuation of companies and assets. It's always similar, this discounted cash flow model. Here I just show you an example, a simple spreadsheet, how this can be done. Here only figures of 5 years are considered. And you see it in the first line, you have the net turnover. And then you have an estimated, so this is a royalty relief method, you have an estimated license rate. This is also important to determine this because it's different in any industrial field, of course. And this is very important, even you get it from the client or from the user himself, what is a typical license fee in this, for these products. The proportional factor indicates what proportion has this invention, this covered invention of the patent in the whole product. So this may be even 100% if the patent covers the whole product. But if it's only a small part and you can really set up a factor, this should be considered. And then you get the license income here. So this is because this is the relief from royalty. And then you have to consider the tax of the company, the typical tax. And here what we also considered, if it's available, this data, you have the patent maintenance costs. They started in 2012. For some reason, I don't know exactly what was the reason why we didn't have any 2010, 2011. And 13, 14, this is also. And at the end, you get the income of royalty income based on the considerations of tax and maintenance costs. And usually, the discount rate is calculated by a risk-free discount rate. This is usually this is the discount rate that the central bank offers to the banks, and the risk premium is a discount rate. This is based on a risk calculation. So it would be too complex to show you how we came to this figure. But, and then you get the effective discount rate. And with this discount rate, this means how these future cash flows which are generated, so we say we save income next year, the year after next year, and this is, I can show you or give you an example of why we do this. For example, if you have the money now, is always more worth than if you have the money in 3 years, because you can invest the money. And this discount rate just reflects investigation or investment of this money. So if you have the money which you get in 2 years is less value today, has less value today. And this is the principle based on this discounted cash flow. So you see, and if you look at the first column, you see 0.61 income goes down to 0.55 within 1 year. But if you look to the last column, you have 12.59 income, which goes down to 7.64. So the further away the future payment is, or the cash flow, the less value it has now. So this is why, and in the end, you just add these future cash flows and you come to a value, net present value of 20.01 here. In this case, it's just, you can say $1 billion or $1,000 or what you just had at net turnover at the beginning. So this is an example how such a valuation could look like. In case where you don't have real information about the real benefit of the product. And this is in most cases, nearly every case, it is very difficult for companies to really tell you if there is a patent, what is the real economical benefit they make in their products. Sometimes it's possible. We have some small clients. They really say this patent covers exactly this product, and this product is sold by this price. And then you can use a different way of calculating. You don't need the license. Okay, that was the German standard. Explained you an overview. And here we have our approaches for international standards. Unfortunately, so far we didn't succeed with this. This is just an overview. Sorry, this is just other international standards which are currently available. We have the EIS, used for bookkeeping and accounting. IFRS, these are also standards which tell you something about fair value, but they have no real recipe how to do it. Here, the International Valuation Standard Committee in the US, they have some kind of framework how to do valuations, but we have no ISO standard so far. And so we made the approach to, we triggered an initiative for an international standard with the ESO in December 2007. And there was a global voting, and we got 25 replies and 16 votes in favor. So 16 countries said, okay, we want to set up such a standard, but 8 rejected. And you see these are major countries like Japan, Great Britain, US. And the reason why they rejected this approach was, for example, you see there is not sufficiently focused yet, our example of the standard. Others said it is extremely difficult and complex to build a general evaluation method. Or other countries said incorrect message that universally accepted methodology exists. So they say there is no universally accepted method. Too early, conflicts due to different legislations, lack of national interest. Standardization committee not the right forum to develop such a standard. There's maybe different also political interests involved here. So the ISO decision was a rejection of this approach, but we got the option to resubmit a revised approach, but so far we didn't do it. As we got the rejection of the ISO standard, we tried a European approach via CEN, and here we got 16 votes in favor and 5 rejections. And, but still the request was rejected as only 3 members have declared active participation in this project. So at present there is no CEN approach. What we try is to put the monetary valuation scenario into the project innovation management, which is currently running at the CEN. This is the European standardization body. Okay, this was a brief summary of the standard. I hope you could follow me to some extent. Thank you very much for listening.
Is it working? It is, yes.
Any questions, maybe?
You did say at the beginning that the DIN standard had been created in 2011.
Yes.
Has anybody ever used it? And where?
It's a problem because there is no, as I said, there is no ruling by law that you should use it. But of course, when I do my valuations, for example, I can say they are according to the German standard. And that helps if you have a dispute before the court. The judge always says, how did you come to this value? And I just refer to the standard. And for the judge, this is a real, it helps the judge to decide because he knows that an expert group has set up this standard, so it's not my single view, it's a view of a whole group of people. So this is, and that's a reason for me why you should use the standard. If you do the evaluation in this direction, you can always say, I try to follow this framework, and I have the advantage that in case of a dispute, I can always say I did it based on the German standard. We always have a European standard, an Austrian standard, meanwhile, but this is quite difficult because they say that they put the risk into one figure, and this figure is in the standard. So to me, it's not possible to say, in any case, the risk is the same. But they do it. They say there is a patent-specific risk of a certain percentage. And that's why I don't favor this approach.
But has this then been used in any damage?
So far, I can't remember. But it was not published so far. But
It's for me, it's just if someone wants to do an evaluation or wants to familiarize himself with it, it's always helpful to read the standard, and you can always refer to if you do the evaluation, you can refer to this framework. So that's, to me, this is the advantage. But of course, when sometimes there may be decisions, or even there may be other laws in Germany which refer to this standard.
Yes, got a question here.
How was the reactions of the other companies? Perhaps is they missing other companies who do not validation?
Yes.
Because it must be quite frustrating. I think you try to find a lot to standardize, and this is rejected.
Yes, there was also an opposition period. So it was published, then there was an opposition period, 4 months, and we received some oppositions, and we even revised the standard a bit. But surprisingly, the major complaint was, why didn't we give a real recipe? But we didn't want to do this, because if you have a real step-by-step procedure how to do it, it's not realistic. Because the exploitation scenario is always different. And I even think that there may be cases where you even can use the market approach. Or maybe sometimes a cost approach if there's absolutely no value, or if it's not possible to use a relief from royalty if there are no turnovers, if the patent is unused. But normally, that was a question I received in another presentation, what do I do with unused patents? Absolutely nothing is available, it's just a patent. And so this standard requires an exploitation scenario. And if you don't have an exploitation scenario, there is no value actually. And I think it is like this, because a patent which is not used or cannot be used has no value. Yes?
I work with small companies who have a broad range of IP. Particularly small companies primarily have know-how and very early stage patents. Why have you focused on patents rather than IP? Are you going to extend this to IP?
We have already a standard for trademarks, for example.
IP in general, because
yes.
the value of tangible assets. The tangible assets, IP, same thing.
I see. Now, we did it specifically for technical inventions or technical protection rights, but of course it could be extended. But it was right from the beginning. We even had huge discussions at the beginning. What is a patent? What is really the value of a patent? Because as I said, with the business consultants, they have a totally different view. Because they argue if you have a license fee of say 3%, everything is already priced in. So I don't need to look at the patent at all. They say, if I know this is 3%, I just need the turnover. Of course, I know why they would like to do it, because they don't want to have the assistance of the patent attorney. The business consultant, they want to do it on their own, and they just say, that's why they argue, and we had huge discussions to bring them in, because this standard has been agreed by all the experts. So we had to find a common denominator, a common sense, and that was the outcome. Of course, this is in the economical factors, which I said. Here you look at the market, and of course you have to look, are there possibilities to circumvent the patents? And if you don't do it, you have to say it in your report. You have to say, I didn't consider this, so at least it should be documented how you came to your value. And if, for example, there may be cases where you get an order to do evaluation, and you have a limited amount of resources and money, and of course this should be reflected in your report. So the thing is, the standard just gives a framework, and you should, if you don't use parts of this framework, you should just mention it in the report so that it's clear.
Anders, would you like to?
Yes, I think it's a very good question, actually, because if you're going to value a patent that covers this technology, that has this sort of market segment, you really need to look at the whole picture, because if the customer will have several different options, you need to take that into the big picture. So otherwise, it's not really a valuation at all.
The question is more or less whether the client is prepared to pay it.
Yeah.
If we do a market research, normally we can't do it, we put it external, of course. Because it's also a point we discussed.
is it really possible that a single person does a valuation based on the standard? It's questionable. To me, if you're a patent attorney and only have an engineering degree, it's really questionable whether you are really capable of defining risk factors, economical risk factors. So this is also a point which has to be considered.
Okay, thank you. Go ahead.
This is one of the most important topics for the future of the IP industry, so it's very good.
Thank you.
I think that although we put a lot of arguments against the thin standard, it's very good that you're taking on the challenge. One of the criticisms is that there are so many different methods. You list all the methods which will produce completely different answers. To the point, I recently went to an IP valuator in the UK, and he said, well, what answer do you want? I will have a method that will give it. So how do you address that?
But I said we have the prioritization. So if you use the market approach or even the cost approach, you have to explain in your valuation report why you didn't use the income approach. So you can't just use it. And this, to us, this was the kind of directive or the kind of burden we would shift on the valuator to say, if I don't use the common approach, I have to argue why not. And this is sometimes that's not very easy.
And most of the income-based approaches are transactionally based. And for small companies like I work with who are pre-business, active business, it creates a problem because there are no transactions to refer to. So small companies tend to be relegated to cost basis when their IP is actually working.
Yeah, but I always suggest to use the royalty relief, because this is an approach which even in the text people they accept this, and because this is quite usual, and even in these international standards, EIS and so this also mentioned license-based approach. So if you're a small company, you can always say, by having this patent, I do not have to pay license for my products, and this is a kind of negative income because I save money. So this is the approach if we don't have any figures. But on the other hand, if many of my small clients, they really have one patent for one product, and then it's quite easy to define what is the income based for, which is related to the patent. And I think this is the approach where you can really do the income approach, just separating the turnover which is done by the products which are covered by the patent.
Where you have that situation, how do you differentiate by the value provided by know-how to turnover as opposed to the patent?
It depends on it. If I have a clear, this is the information I get from the client. If I have a clear information about this is the patent, these are the products, I can check whether it's really covered. And if he can explain that he does this turnover with these patents, with the products which are patent, I use this as a figure for the turnover. And of course, you have to mention this in the report that these information came from the client, and whether you checked them or not. This is always a situation where you have to be where you have to mention, where you put information into the report so that you are on the safe side in the end, because there are even meanwhile there's case law in Germany where banks who gave a securitization, who gave a loan based on a patent, they blamed and they filed a suit against the valuator. And sometimes this is $1 million worth of this value and dispute, and it is very difficult. But if you have a good documentation in your report, you can show these are the figures, I didn't check them, and so the bank himself could see this as well. And so this is the kind how you can put your head out of the of the rope.
Okay, thank you. Are there any more questions? No.